welcome back to Act 2 of this 3-part mini-series, where we are getting into the truths you haven't been told about trust. I hope you are ready because things are really starting to get interesting now. Previously, we finished on the high note that the Bank of England notes allow you to go to the Bank of England to demand from the chief cashier the fulfillment of their promise, which is to be given the value of the note in equal pounds in mass of gold. Well, let the story continue. Yeah, well, that was all wishful thinking. Not too fast there, buddy. There's a catch. The catch is that the bank no longer has to make good on their promise. They never have to fulfill their promise. And this is actually accepted by law. They have absolutely no liability against them for this. I mean, let's think back to the book scenario that I proposed to you in the first act. Can you imagine if I promised to give you the book endlessly, but I never gave it to you at all? Can you imagine if a law was passed where you had to accept that my promise that I'd give you the book was sufficient, as if I had actually physically given the book to you, and by law you would have to accept that the promise that I made to you was going to be, by law, may I emphasize, treated as the book itself in your hands. I'm sure you would not be very happy about that, would you? I mean, I would basically be robbing you of property that you're entitled to, no? So this is kind of akin to what is going on with the banknotes. They are a promise backed by another promise, backed by another promise, backed by another promise, and another on top of that, and oh, hey, don't leave that last promise that's left on the table, because that's valuable, remember? Let me show you the evidence that what we have discussed is true, because the Bank of England themselves say it on their webpage, under the webpage called Exchanging Banknotes for Gold. Let's look closely at each section and really break each of them down to make sense of all of this. So this first bit, the banks say, since its foundation in 1694, the Bank of England has issued notes promising to pay the bearer a sum of money. For much of its history, the promise could be made good by the bank, paying out gold in exchange for its notes. The link with gold helped to maintain the value of the notes, although the link was sometimes suspended, for example, in wartime. Okay, so from this, we can gather that the gold was the physical value, with the note acting as a security, so a financial instrument that is used to evidence ownership or a debt. In the past, you trusted that the note had value and that the promise had actual value because you knew that by law, when you took it to the bank, you would actually get physical gold in return. This maintained the value that the notes represented because £50 on the note meant £50 of the mass of gold. But also, the gold itself was value because, well, it's a finite resource, right? Meaning there's a set limit of it, which makes it inherently valuable. I mean, there's a reason why limited edition things always sell for more money than the standard edition, right? The limited amount of physical gold meant that logically there would always be a limited amount of notes in circulation. So you couldn't just make notes because you wanted to without first having the physical gold. Essentially, so that notes couldn't just be made out of thin air. There needs to be gold first before a note can be made. Obviously, this becomes problematic if people begin to hoard their gold or the notes that represent the gold instead of actually spending them, which helps keep them in circulation. And the more that's hoarded, the less will be in circulation, and then the less will be available for people to actually use to buy goods and services to live. A key point that I find very interesting and cannot be a coincidence is that they state that the link with gold was suspended during times of war. Well, following what we have been talking about, you may start to wonder if this means we are currently at war. You'll see exactly what I mean in the next slide, but you may begin to wonder if we are currently at war and we don't even realize it. The bank goes on to say the link with gold was finally broken in 1931. See in particular the Currency and Banknotes Act of 1928 and the Gold Standard Amendment Act of 1931, when the UK came off the gold standard, and since that time there has been no other asset into which holders have the right to convert Bank of England notes. They can only be exchanged for other Bank of England notes. Nowadays, public faith in the pound is maintained in a different way through the Bank of England's operation of monetary policy, the object of which by statute is price stability. So we can see the gold backing of the currency was ended in 1931 through the Gold Standard Amendment Act of 1931 in the UK. So this act allowed the bank to no longer fulfill the demands for gold without liability to them. So now if you take a banknote to the bank, they will simply exchange it for another note of equal value. As the banks say themselves, there is no other asset into which holders have the right to convert Bank of England notes. They can only be exchanged for other Bank of England notes. This clearly shows us that the gold was the asset and the note was the liability instrument, a liability of the bank. So if the notes are the liability, they are evidence of a debt, which is what a security is, which can only be converted into another liability, then we can see our money system is based in debt entirely. And this is what is known as a fiat currency as well. This therefore means that when you use the currency to supposedly pay for goods and services to sustain your life, then actually, whether you realize it or not, you haven't actually exchanged any real tangible value, because evidence of value in the form of a banknote is not true value in itself. The true value is an asset. A liability is not true value if it is never fulfilled. However, we now have a system where liabilities are treated as if they are assets, which is astonishing. I mean, just think back to the book scenario I mentioned in Act 1. If I keep promising to you the book, but I never give to you the book, would you start acting as if the book is your property and then you try to sell it or loan it out or other things like this? I mean, it's absolutely absurd, isn't it? The next section reads, the Bank Charter Act 1844 and the Currency and Banknotes Acts of 1928 and 1954 provide for the establishment of a distinct department within the Bank of England, the Issue Department, and for the issue of banknotes. This legislation also requires notes issued by the bank to be backed by securities. The concept of securities was broadened by the Finance Act 1932 and is now reflected in the amended 1928 Act, held in the issue department, and confers legal tender status on Bank of England notes. So we see that the bank are required to back the currency with securities. What does that mean exactly? Well, in the Currency and Banknotes Act of 1928, it defines securities as an expression that includes securities and assets in whatever form held. This is a very, very broad definition, and the word includes shows us that there is no limitation clause at all. So what makes up a security is so broad and has virtually no restrictions on what could be defined and categorized as a security. This makes you think, with such a broad definition, then surely it means that some documents and instruments that we wouldn't normally think would be a security could actually be considered and treated as a security under the law, because this definition is just so broad. Also, it is also a key point here that securities cannot be defined by the word securities itself. You cannot use the word you are defining in the definition itself. I mean, this is completely counter the idea of a definition, which is to bring clarity to what a word means. Ask yourself, has this definition actually helped you figure out what a security is? So what does all of this mean? We have discussed the different sections in detail, right? But let's just try to bring everything together. So we can see that whoever makes a promise to pay is the one liable to make the payment. If you use your country's national currency, which was created by the central bank, this means that you never actually pay anything at all, as you haven't made a promise to pay, so you don't have the liability. The bank are the ones who create the notes so that you can use them to get goods and services for you to be able to live, right? So you can sustain your life, which you have a right to. This therefore means that there is a relationship between you and the bank, and you are a beneficiary. I mean, whoever creates can control, right? So the bank have the liability and the control, which therefore places them in the position of a trustee automatically, with a fiduciary role, may I add. If you therefore use the currency of your country to get goods and services, you, my friend, are the beneficiary of a hidden trust relationship and you didn't even realize it. Remember, trust can be at play without the party's knowledge. There's more. The UK government is a concept that the people created, right? And the government is, in theory, supposed to be for the people. They are public servants after all. I mean, that is their job title for a reason. So we can say in trust law terms that the people created the government in the position as settler, the government managed this relationship and the terms, so they are the trustees, and they follow a trust deed, which is our laws, right? The written laws and the customs are literally the trust deed for this trust. Then you have all of the individuals who make up the collective idea of the people, who are supposed to benefit from the work of the government, so they are beneficiaries. This is yet another hidden trust relationship. You may wonder, well, what is the property in the trust, right? There has to be trust res. Well, this would be resources such as the physical gold still at the Bank of England held for the UK government. Public venues, anything that's accessible to the public is very clearly the trust res, because it means it's property belonging to the government in some way, which you are an individual beneficiary of, where you can actually use that property. And guess what? The Bank of England themselves, they are nationalised, meaning that it is actually property owned by the UK government, which is even proven by the fact that profits that are made by the Bank of England, I wonder how those are made, any profits that are made by the Bank of England are passed over to the UK Treasury, which is the government department which are directly involved in the management of the public finances, which makes them trustees liable to payment. Oh, and of course, we can't forget that whatever the Bank of England own as assets under that name is ultimately owned by the UK government, which is ultimately owned by the people, right? I mean, I'm following a logical trail of thought here. This all shows us that all of these relationships are all based in trust completely. So what does this mean in relation to your property exactly? Well, if you use currency that is completely and entirely based in a trust relationship to get your property or to get services to keep you alive, then what you have actually done without realizing is obtained property into the trust. You use the currency, which is a trust tool and a mechanism in itself, created by a bank that is nationalized and owned by the government, which is a trust in itself as well, in the way it operates. So it is all a trust within a trust within a trust. Then what you actually did is obtained property for the trust. You never paid for anything, remember, because you didn't make the promise. You're not the liable one, and there is no real asset backing the currency of our country anymore. So the trustees, also known as the government agents, they need to know exactly what it is that has now become subject to the trust of which they have a fiduciary responsibility to manage for the benefit of an identifiable individual beneficiary. Because it's that identifiable individual beneficiary who is the one who will have benefit over that specific property that they have just added into the trust. It won't be for the benefit of any other identifiable individual beneficiary collectively. It is just for them, right? So in effect, we all have our own private trust account as such with the government, like a branch of the trust just for you. So we are able to show clearly which property specifically belongs to which beneficiary, and also which rights that specific beneficiary will have regarding specific property. Hence why that property will be held in your name, or the acquisition of that property will usually be completed through, for example, your national insurance number, things like this. This therefore explains why we often have to register property, whether this is your home, your car, or even your offspring, or what people typically call children. So with all this information, you may begin to question then, if everything is a hidden trust relationship and I'm the beneficiary, then how come my property can be taken away from me by the very people that are supposed to be my trustees, may I add, to settle so-called debts? So the answer to this is very complicated, but it is my aim to break things down for you to make things clearer over time in a simple way. But in the most simple way for now, it is all happening because the trust relationship is occulted, meaning it is hidden. That is all occult means, by the way. When you look at the etymology of the word, it literally just means hidden from view or secret, right? So there is a secretly hidden away trust relationship that no one is actually identifying and expressing, never mind expressing who they are and what position they actually occupy. It's all guesswork at this point. So yes, everything is a trust relationship. Anything that has money involved, which is pretty much everything, is actually a hidden and occulted trust relationship. Or it could be a contract between a business and a trust. The real key thing I need you to really grasp is that a trust relationship can be at play without your knowledge of it. You do not even need to know what the concept of trust is at all for a valid trust to be at play. It will all come down to how you behave and you see things. And when issues arise, well, they arise when you do not know or you cannot recognize that there is a trust at play, and most importantly, who is in which role. Because essentially, we are always acting out a role, whether we realize this or not. It's about which one are we actually playing. Trust can be evidenced through conduct, and your conduct will reveal the hidden relationship and the position that you've decided to take up, which automatically, the way in which you behave will show implicitly your consent to behave that way, and therefore your consent to the role that you're acting out. Don't forget as well that we are all presumed to know the law because ignorance of the law is no excuse. And this isn't wrong. This is why we make these presentations, to help you know the law so you are equipped with the knowledge that you need to be able to navigate through life in a different way. So hopefully you are beginning to see how you are actually a beneficiary, but if you act like a trustee, then you're actually doing something wrong here. You are deceiving others without realizing it because you are truly a beneficiary, but you are acting like a trustee-de-son-tort, a wrongful trustee. Now, how do we actually recognize the position that we're in? What role are we playing, or which role has been imposed on us? Well, I have an easy guide for you. Ask yourself, is someone asking or demanding you to pay something? If the answer is yes, then you need to recognize that a trust is being settled against you. So someone else is acting as the settler, and they are trying to get you to take the role of trustee. So they are presuming you are the trustee and that you will accept this role. And it will be most likely that the one in the settler position is going to claim beneficiary position at the same time, right? I mean, they probably want you to pay them. Then another telltale sign that something is not quite right is if someone is asking or demanding you to do something or not to do something. If this is the case for you, then again, you are being presumed as trustee with obligations to act a certain way for the benefit of someone else. So we know that a trust to be in operation, we need to have some sort of property around. The thing about property is that literally property is anything that can be owned or has an owner. The legal definition of property is the right to possess, use, and enjoy a determinate thing, the right of ownership. So we can see this definition is so broad. The determinate thing and the right to own it. I mean, this applies to so many different things, right? You can see that anything that can be owned can be property, which will include your rights, such as your right to life, your papers, such as your legal paperwork you create, your documents, such as government-issued documentation, your works of copyright, so for example, your signature or autograph, your intellectual property, for example, any ideas that you create, any titles to property, such as beneficial title, your car, your house, your dog, your physical body as well. I mean, the list is endless. Here's a clear example. A letter has come in the post, which is demanding payment. It has come through your letterbox. This, believe it or not, is evidence of a trust being construed. So the paper itself is property, and that property has the logo of the company making a demand for payment on it. So the logo itself and the paper itself is their copyright property. But this has now ended up in your hands, right? So what's going on here? Well, you are being construed as a trustee, and they are assuming that they are in the beneficiary position. But there are a few things to consider. Can they prove that they are a beneficiary? Do they have a contract or a deed that is valid which proves this, which the law would recognize as valid and enforceable? Or is it that there is a unilateral imposition of duties? And did you consent into this? These questions are all super important because there is a maxim in law that he who asserts must prove. So they need to have proof of these claims, right? So this last example set us up nicely for the end of Act 2. If you thought this act was juicy, then I cannot wait to show you what Act 3 has in store for you. So I'll see you on the other side.